Welcome back here on the Senior Network. We're now joined by Mr. Neil Honeycutt, Director of Community Relations, Right at Home.
Thanks for having me, Greg.
Sure. And again, Brian Tracy, owner, attorney, Elder Law and Estate Planning Center. And by the way, thank you. We're in your home today. Very nice. We appreciate it. We do. I can see someone must have cleaned. I'm just kidding. It looks great. It does. Brian, tell us, on the last show, we were really talking about cognitive decline and some of those. We really didn't get into dementia and Alzheimer's. We were just talking about just basically aging and cognitive decline. Right. I know you have to see this in your business.
Yes. Just as in any estate planning business, for any attorney that's involved in doing a certain number of wills or trusts, the ability of the person signing the documents is usually something that has to be looked at right away. Right. You know, if a younger couple comes in and it's obvious there's no issues as far as their ability to understand what they're signing, then it's not an issue. But in the practice of elder law and estate planning, many times the client who is going to be signing the will is brought to the office by a child or a caregiver, right. And that person will say, "Well, here's my dad, and he wants to he needs a will." And I talk to Dad, and I say, "Well, Dad, what do you want in the will?" And he's like, "Well, what's a will?" Yeah. So just because someone is present in our office and declares an intent that they want a will, that there's other things to consider, and that's their ability. And the problem is that there's no form or checklist that I can go find and ask that older client, and if he answers correctly 9 out of 10, I let him sign the will. It just doesn't go that way. So many of the times it's just common sense. When you find someone that has a little bit of cognitive dysfunction, it doesn't mean they have a little bit. They could even been diagnosed with some form of dementia weeks earlier, but just some form of dementia is not a disqualifying factor. Sometimes it's just common sense. It's just sitting next to the person and asking them some questions about their kids,
sure,
about their estate, what they like to do with it. And if they answer satisfactorily, they can sign the will. And as a matter of fact, signing the will is often a misunderstood idea too. An individual may be disabled physically as well, right, and not able to sign with his full signature. An individual can sign a will with an X. Just make an X. Yeah. If they can't because they are physically disabled, they might have it all up here mentally, but if they cannot physically fix their signature to the document, they're allowed to sign with an X. Of course, the notaries and the witness have to put a qualifying statement at the end of the document to say, "I saw that person sign with an X," and indicate that was his signature for the purposes of that document. But that's also interesting also that physical disability or physical incapacity doesn't render someone disqualified or unable to sign legal documents.
Didn't know that.
Yeah.
And I'm sure, Neil, when you walk into a home a lot of times, you probably see the same thing, right?
Absolutely. As a matter of fact, we've just had some recent folks who've really needed some assistance in this. Thought he initially was competent and able to make some of these decisions, but as we've gone further along in the process of observing, and like you said, sometimes it's common sense by what the reports we're getting from caregivers, sitting down with folks, you realize they're really not able to make some of these decisions. And like you said, sometimes people can, but in a couple of cases we've seen lately, they're just they're declining at such a rapid rate that you have to bring others in to help them. And that's where you come in, people like you.
Common sense also tells us that if there's a question as to capacity, a sincere question, whether or not the person does have the mental capacity, then we turn to medical specialists. Well, even a physician's statement for our file that we can put in the file that this person has the capacity to understand their estate and understand their family. Sometimes we demand that before allowing the individual to sign the documents because we have an ethical obligation. Attorneys can't just stick documents in front of individuals and tell them to sign it. We have to make sure that they understand basically what is in the document. And sometimes when there is a doubt in my mind and in any other attorney's mind, the best thing to do is let's see what a medical professional says as far as the competency is concerned, and sometimes that turns the day. That makes the difference in whether or not we go forward in allowing someone to sign a document like that.
So the two of you, would you, I know you're handling all legal documents and you're doing the social work side of it. Do you bring a third party in if there's not a power of attorney and try to have someone become that power of attorney?
Unfortunately, we can't have someone appointed a power attorney because we think it's a good idea. Neil and I could have a discussion about a common client or a common family, say, yeah, that older one that lives in the neighborhood is very responsible. We think that person ought to be the decision maker. Well, it might be the right decision, but we can't, by Neil and I agreeing to it, have that person. If there's no power of attorney, unfortunately, if there's no power of attorney in that case, and decisions need to be made, unfortunately, the family has to resort to court and apply for guardianship. That's why we preach the gospel of having everyone obtain a power of attorney now, before the day comes when they're incapacitated, because we don't know when that day will be. We don't know if that day will come. So get it now and have it in your possession, because it saves a lot of problems when the caregivers come to the home, and you know, who is it that we're supposed to turn to make decisions?
That's
because our client, our patient, is unable to. So who in the family makes the major decisions?
Yeah, sometimes we're very fortunate that we walk into situations where the individual is at that, I would say, probably at that last level of ability to make some of these decisions, and fortunately they're able to do it. And then you're exactly right. When you get into a situation, you walk in with someone who lives alone, there's no friends and family, they're clearly not making the good decisions. You're right. There is no way to really, there's nothing you can do except through a court appointed. That is absolutely it. And you're faced with a lot of challenges there too, because you want to do everything you can to help the person, but you're just not able to. You don't have the teeth to be able to do it without that.
Right.
We'll hold that thought. We're going to have to take a break. Stay with us here on the Senior Network. We'll be right back.